Hello everyone. I am Srimati Shubhalakshmi P, Assistant Professor of Law, SDM Law College, Center for Postgraduate Studies and Research in Law, Mangaluru. Through this video, I am discussing on the concept of gift as how gift can be made, parties involved in gift, procedures of making gift, etc. This video is under Pan-India Legal Literacy and Legal Awareness Program conducted by Center for Environmental Law, Education, Research and Advocacy, CEERA, National Law School of India University, Bengaluru, under the aegis of Department of Justice, Ministry of Law and Justice, Government of India. To begin with, I'm sure all of you heard about the gift, like giving gift, receiving the gift, etc. The legal provisions relating to gifts are discussed under Chapter 7 of the Transfer of Property Act 1882. Then, what is the gift all about? Who can gift and to whom gift can be given? Who are the parties involved in the process of gift and what are the subject matters of gift? Then there will be a question in your mind. Anything what you possess and own can be gifted? Then what are the essentials for that particular thing which you have to give? Okay, fine. If you have a gift, can you take it back? I mean to say, can it be possible to revoke the gift given? Whether registration of gift is mandatory? What are the tax which are there on gift? Let me discuss all these concepts through this video. Gift is also one of the methods through which transfer of property can be made possible. According to Section 122 of TP Act, it defines as like this. A gift is the transfer of certain existing movable and immovable property made voluntarily and without consideration by one person called the donor to another person called the donee and accepted by or on behalf of the donee. It is a gratuitous transfer, which means that it involves no consideration and it is made voluntary. Then, who are all the parties to a gift? Who are all will be there in that particular transaction called gift? There are two parties. One is donor and another one is donee. Donor is a person who makes the gift and donee is a person who receives the gift. In brief, we can say one who transfers the gift is the donor and the transferee of the gift is donee. Do you know the qualifications for a donor and donee? For everything, we have to have some qualification. Then what about the donee and what about the donor? The donor must be a competent person. He should have capacity to enter into contract. Then we can say that he is deemed to have a capacity to make the gift. This implies that at the time of making a gift, the donor must be of the age of majority and he must be a sound mind, etc. Then only natural person can be the donors or even others also. Even registered societies, firms and institutions, they are also referred as juristic persons and they are also competent to make gifts. Gift by a minor or insane person is void. That is not permitted. Besides capacity, the donor must also have the right to make the gift. The right of the donor is determined by his ownership rights in the property at the time of the transfer, because gift means the transfer of ownership. Simply, we cannot give something without the ownership. That's why there must be transfer of ownership when you are going to gift something to the donee. Donee need not be a competent person. I mean to say, he need not be a person to be competent to enter into contract. He may be any person in existence at the date of making the gift. A gift made to an insane person or to a minor or even a child existing in the mother's womb, that is also valid, but subject to its lawful acceptance by the competent person on his or her behalf. Juristic persons such as companies, firms, institutions, they are deemed as competent donee and gift made to them is valid. However, donee must be an ascertainable person. See, if the gift is given for a general public, it is not considered, it is void. You must specifically name the person to whom you are making the gift. And there may be more than one or two or more than two persons as donee. Then let us see, there will be a question in you as to what can be gifted and what are the subject matters of gift. Any movable or immovable property can be given as gift, but the property must be in existence with the owner. Gift deed must be tangible and transferable in nature. If a gift is made which consists of both present and future property, then gift of present property will become valid and gift of future property will be considered as void. But here, the compact of this transaction will never be considered as void, but only the future gift is considered as void. Then what are the essentials to consider a gift as a valid gift? Or we can say essential elements. When you are going to give a gift or making a gift, then what are the requirements, the things you should bear in your mind? First thing is existence of parties. Second one is transfer of ownership. Third one is existing property. Then transfer without consideration. Voluntary transfer with the free consent. That is also important. Then acceptance of the gift. So if you look into existence of properties, as I have already explained here, existence of property is some existence of parties means there must be existence of donor and donor. Both the parties should be there, and with their competency, they can make as well as they can receive the transfer of ownership. Here, the transferor, the donor, must be divest himself of absolute interest in the property and vest it in the transferee, that is in the donee. So the vested right of the owner is must. Transfer of absolute interest implies the transfer of all the rights and even the liability in respect of the property. Whenever we say existing property, what is that existing property? I mean to say existing property here may be of any kind. Property may be of any kind, may be movable, immovable, tangible or intangible, but it must be in existence at the time of making the gift, and it must be transferable too. Gift of any kind of future property is deemed to be void, it is not valid. And a gift of special succession, I mean to say expectation of succession or maybe mere chance of inheritance of property, all these things cannot be given as gift. They are considered as void. So transfer without consideration is also very important. When we say transfer without consideration, there should not be any single pie or nothing should be given to the donee in return for that particular to the donor. Transfer without consideration means a gift must be gratuitous. The ownership in the property must be transferred without any consideration. Even a negligible property or a very small sum of money given by a transferee in consideration for the transfer of a very big property, that would make the transaction either a sale or an exchange, not a gift, because you have taken some amount, maybe minor or a small amount or whatever, but you have taken it. So the consideration is pecuniary in nature. I mean to say monetary terms. See, in case if father wants to give his property to his son or daughter, in return he wants to take some love and affection, or with love and affection, in such case it is not pecuniary consideration. So if you do so, it is considered as valid gift. And in case if a transfer of property made in consideration for a service rendered by a donee, that is also considered as gift, because there is no monetary transaction here. But if it is a liability of the donor to give something to donee, and then it is not gratuitous and it is not even a gift, because liabilities evolved pecuniary obligations here. When we look into voluntary transfer with free consent, it is nothing but the person who gives the gift, I mean to say the donor, must make the gift voluntarily and with the free consent. It should be free from any force, fraud or coercion or undue influence. Nothing should make him to give. It is just he should not have been forced by somebody, or no much coercion or no such coercion or undue influence. Donors will in executing the deed of the gift must be free and independent, with the full knowledge of the circumstances and the nature of the transaction, what he is doing, to whom he is gifting, what is the after effect, everything he should know. Otherwise, it is not a free will, it is not a free concept. So acceptance of gift is also very much necessary on the part of donee, because the donee must accept the gift, and then it should make, then only we can say that gift has been made in a proper way. He should give, whenever he is going to give a gift, or a person is given a gift to other person, he should be getting consent from that particular person. In case, if someone interested to gift to you an elephant, and you are not willing to accept it, then he cannot give that elephant to you as a gift. So donee may refuse the gift, as in cases of non-beneficial property or onerous gift, like a gift with some burden. Then acceptance of gift is necessary, and it may be either express or implied form. If donee acted upon the gift positively, also sufficient. Mere silence is also considered as acceptance sometimes. Why? Because if a person is given with a gift and then he maintained silence, that can be deemed to be accepted, but provided the knowledge of the gift being made to his favor should be there to the donee. Then what if the donee is incompetent to contract? Then how can we give a gift to such particular person, or how can we make a gift to such incompetent persons like minors or to insane, or a gift must be accepted by his or her behalf by a competent person in such case, like guardian on behalf of a ward, or by a parent on behalf of their child or children, etc. What if minor, after reaching majority, feels that such gift given to him is not acceptable? He doesn't want it now. What he can do? Then in such a case, a minor, on attaining his majority, he may reject the gift. And if the gift is accepted during the lifetime of the donor, and the donor dies before the registration or other formalities which are required, the gift is deemed to have been accepted, and gift is valid also, because giving gift as well as receiving the gift of acceptance, everything is done in a proper manner when both are alive. Then if we look into actionable claims may be unsecured money debts or right to claim movables not in possession of a claimant. Actionable claims may be transferred as a gift by an instrument in writing, signed by the transferor or his duly authorized agent. Registration and delivery of possession are not necessary in such cases. When we look into onerous gifts, one who accepts the benefit of a transaction must also accept the burden of it. Thus, when two properties, one is onerous and another one is prosperous, are given in gift to a donee in the same transaction, he may accept the gift together with the onerous property or reject it totally. If he elects one in any one of them, it is not sufficient. What he should do is, if he elects to accept the beneficial part of the gift, he is bound to accept the other which is burdensome. So we have to be very, very careful when we are going to receive a gift also. There may be burden also on the other hand, and there may be prosperous thing also. What about universal donee? He is a person whom the entire properties of the donor has given. In order to treat any person as a universal donee, he would have received the whole property of the donor without retaining a single pie with him. That are both movable and immovable property. He is liable personally for all the debts and liabilities of the donor, and the universal donee is responsible to universe for his donor's debts and liabilities only to the extent of the amount he has received at the time of the gift by the donor. Then the gift which we have given or anybody has given to other person, or a gift which is made, whether you can suspend it or revoke it, That is another important question what will be having in your mind. Under section 126, revocation or suspension of gift is discussed. It provides that legal provision which must be followed in case of conditional gift. Revocation by mutual agreement is one of the ways where you can revoke the gift, where the donor and the donee mutually agree that gift shall be suspended or revoked upon the happening of a certain event, not depend on the will of the donor. It is called as a gift subject to a condition laid down by mutual agreement. But such conditions must be expressly laid down as per law. Then what about another important thing, how you can revoke a gift? That is revocation by the rescission of the contract. If the preceding contract is rescinded, then there is no question of subsequent transfer to take place. For example, if a gift is not made voluntarily, the consent of the donor is obtained by fraud or by misrepresentation or by undue influence or force or coercion, the gift may be rescinded by the donor. The option of such revocation lies with the donor and he cannot be transferred. It cannot be transferred. In case legal heirs came to know that the donor had intention to make the gift which was because of undue influence or fraud or coercion, and it is done without free will, then the legal heirs of the donor may sue for revocation of such contract even after the death of the donor. But after how many years they can revoke it? Once gift is given, how many years? After how many years you can take it back if such event happens? The limitation of revoking of gift on the grounds of fraud or misrepresentation, etc., is 3 years from the date on which such facts come into the knowledge of the plaintiff or the donor. When the donor ratifies the gift, either expressly or by his conduct, even after these things are happened, then revocation is not possible because he has ratified it, he has accepted it. Then what about the registration of gift? I was telling registration is compulsory or not. Registration of gift is mandatory, especially in relation to immovable property. A gift deed is a legal document availed after sanctioning the transfer of a property to the beneficiary. A certified professional will evaluate the property related to this gift deed. A gift deed will be signed by the donor, donee, as well as in the presence of 2 witnesses. And you need to approach a nearest sub-registrar to submit the signed documents. Then hire a lawyer or an advocate for the calculation of the registration charges, including the stamp duty, and you need to pay the prescribed fee also. I will tell the important aspects relating to this a little while. Attestation of the deed also required. Then for the gift of immovable property, registration is mandatory. In the case of a movable property, it may be completed by the delivery of a possession, and it is optional. Registration is optional here. The gift of a movable property effected by delivery of possession is valid, irrespective of the valuation of the property. With regard to immovable property, registration of transfer of that particular gift is necessary, irrespective of the value of the property, and registration of a document, including gift deed, implies that the transaction is in writing, signed by the executant, that is a donor, and attested by 2 competent persons, that is, they are witnesses, and duly stamped before the registration formalities are officially completed. For example, that differs from city to city, especially if you look into registration in Bangalore. In Bangalore, the stamp duty and registration charges depend upon who is giving the gift property, etc. If the donee is not a family member, then the stamp duty will be payable at 5% along with the surcharges and cess. Registration fee is 1% of the total market value of the property. If the donee is a family member, then the registration fee will be 1,000 rupees, 1,000, and the stamp duty will be there. If the property is situated within PMRDA or PBMP, city corporation limits, The stamp duty will be rupees 5,000 along with the surcharges and cess. If the property is situated within city, town, municipal or council or a town panchayat limits, then the stamp duty will be rupees 3,000 along with the surcharges and cess. If the property is situated within the limits of other than the places which I have mentioned above, then the stamp duty will be rupees 1,000 along with the surcharges and cess. These are certain important things which we can understand with regard to when we are going to making a gift. With regard to tax, gift tax, the tax payable on the gift, how you can pay the tax, whether you have to pay the tax on gift, all these things are also very important when we give or receive the gift. It comes under the Income Tax Act of 1961, and according to this, if the gift is received in, it is received in certain situations, they are not taxable. Otherwise, they are taxable. When an individual receives a gift from a relative or blood relative, or on occasion of individual's marriage, under a will or by way of inheritance, and a gift received in contemplation of death of a donor, or a gift from any local authority, panchayat, municipality or university or educational institution or a hospital, or from any registered charitable or religious trust, etc. Members of HUF who receives a gift from HUF on partition of an Hindu undivided family, etc. Such gifts are not taxable. They are coming under exemption. The gift will be imposed with the taxes in some other condition in the hands of recipient of the gift. Immovable property having stamp duty value exceeding rupees 50,000 and shares or maybe jewelry or any other valuable art or thing, so whichever it may be, which was market value exceeding rupees 50,000 received as a gift without consideration will be taxed. So it is taxable under the head income from other sources. That is the fifth head under taxation. To conclude, I can say that there is a concept called donatio mortis cosa, means deathbed gift. If a gift is made when the donor is seriously ill or suffering from a disease which actually causes death, donation made out of fear of death or in contemplation of death, that is called as deathbed gift, differs from all other gifts. We can say it is an exception. When gifts are made, it should be made to right person on a right time, because it cannot be revoked at the will of donor only. In Srimati Satyabhama Bai versus Raghunath, it was held that once the gift deed is done and donee has accepted the same, then unilateral revocation of gift deed already executed is permitted. To protect parents and elderly persons who have signed away the property to their children, they can make it back if, they can take it back if they are ill-treated by their children. The Bombay High Court recently declared that property given to their son in the form of gift can be taken back. So we can say that gift is one of the feasible method of transfer of property from one person to another person, but need to follow all the procedures required for valid transfer of gift. Thank you.